defense.
You want to take that down then, or just close it? Good afternoon, everyone. Wanted to start by telling you what the purpose of closing argument is. It's, of course, my chance to speak to you. This is my last chance to speak to you as jurors. I don't get a rebuttal. The state does, so they still have an opportunity to come up here and speak to you again. This is the only opportunity that I have, and so I just wanted you to be aware of that. When I got up here in opening, it feels like ages ago now, it was 2 weeks ago when I stood up here and talked to all of you, and you've listened to a lot of testimony. I asked you to keep an open mind and to study the evidence closely. And I'm going to make the same request of you here today, tomorrow, when you deliberate, to study the evidence closely. You've been given a mountain of materials, and the judge has read a lot of instructions to you, and I want to talk a little bit about those instructions because as you hear Judge Crivello reading the instructions, it sort of goes on, but you're going to be given copies of those to take back with you to study closely and examine. And I ask that you look at those closely and pay careful attention to everything you heard in this case. The most important principle in the criminal justice system is the idea that a person can only be convicted if the district attorney's office has proven a case beyond a reasonable doubt. That principle has been with us for hundreds of years since the country was founded. The reason why that principle is so important is because it's crucial that when somebody is charged with the most serious of crimes, that we have absolute proof beyond a reasonable doubt by the district attorney's office, that when they decide to bring such serious charges against a person, that you are convinced beyond any reasonable doubt that in fact Mr. Anderson committed each one of these crimes. When Judge Crivello spoke to you, she talked about what reasonable doubt means. Reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. So you can look at evidence as well as lack of evidence. It means such a doubt that would cause a person of ordinary prudence, meaning any of us, to pause or hesitate when called upon to act in the most important affairs of life. And of course, this is the most important affairs of life because you are deciding Mr. Anderson's guilt on, or whether he's not guilty on each of the counts. Another important instruction the judge had read is that each verdict, each count in this case, requires a separate analysis. And when I listened to the state's closing, I heard a lot about what their theory is with respect to intentional acts that they believe were committed after Sade passed away. I heard a lot about intentional acts that that Mr. Vance Curzan talked about in opening and again here in closing. But I want to emphasize that when you go back to the jury room and you evaluate the evidence, you are required to evaluate each count separately. And what the judge told you, what Judge Crivello said when she read the instructions a little bit ago, is that your verdict for the crime charged in one count must not affect your verdict on any other count. Why is that important? It's important because this is a highly emotional case, obviously. We all know that. We all know that it's that type of case. And we'll just call a spade a spade. I mean, we have a victim's family sitting right here. We just heard them applause when the state finished their argument. I don't criticize them at all, what they're going through. It's not at all what I'm here to do. I can't even imagine it. Can't imagine it. But here's how the system works. We get 12 jurors together. We have 15 of you here, and you've been amazing jurors, all of you, here on time, ready to go, listen to everything. And what we try to do when we're representing somebody and representing Mr. Anderson is we try to pay attention to what's happening in court, but also all of you, because your decision is what really matters. It's not what Mr. Vance Curzan says. It's not what I say. It's really what all of you say once you go back in that jury room and carefully consider the evidence or lack of evidence. And it's important to evaluate each one of these counts separately. And the judge told you, as hard as that can be in cases like this, to try to check your emotions at the door. I know it's hard. I I don't think any of us envy any of aspect of what our jobs are. We all have a job to do. The most important job is yours, and it's to check your emotion at the door, put aside passion, put aside prejudice, and look at the case from the evidence. That's all I ask you to do. And on each count, render a separate verdict unanimously. All of you agree. And there's a number of things I could say to you. The idea here is that each side is given 45 minutes. I don't know if I need 45 minutes when you've sat here and heard everything the same way I've heard everything, and the same way the state has heard everything. We try to look at the jurors to see, some people are taking lots of notes, some people are taking less notes, and at the end of the day, really it's just what you remember and what you ask to see. That's what counts. And you can ask to see anything. You can make a request when you go back there of the judge to view videos again, if that's something that you'd like to do, or look at DNA reports or look at photographs. You can make those requests, and I would encourage you to do so. And so I'm going to touch on some of the points that I think are important. You may agree with me, disagree with me, but this is my chance to present to you what I think are the important points in Max's defense. We do have separate crimes that are charged here. Obviously, if we broke them into sort of broad categories, there's the state's theory that Max intended to kill Sade Robinson. So that seems to be the glaring charge, of course, that is here. We also have charges of dismemberment, hiding a corpse, and arson of a vehicle. I'm not going to go through each of the elements of every one of these crimes with all of you, because that will go back with you to the jury room, and you can read those and decide. But we start with the fact that everything the state showed you in this case was that Max had met Sade. You saw the videos that were just played again in closing. The two of them met each other, and the two of them went out in public. They texted, they made arrangements to go out, and they went to places. When you watch the videos, they went to places that Max is known. Places where he was interacting in a friendly way with bartenders, where people were talking to him on a first name basis, where he's shaking hands with people, where he's having normal drinks, normal behavior. They go to Twisted Fisherman, they spend time there together. There's nothing in the videos that you've seen that suggests that Max is planning to do anything like an intentional homicide. There's nothing in the text messages that even comes close to suggesting that. Because of course, intent does have to be formed at some point, as they just said, and as the judge told you, before a person passes away. Nothing about the Twisted Fisherman video shows for 1 minute an intent to kill. And the same is true with Dukes. They go there, they're sitting at the edge of the bar, they're playing beer pong with another couple that shows up. Again, you can see, even if you want to watch the video again, you can see when Max leaves, he's saying goodbye to people that know him. Obviously, he used to work at Twisted Fisherman, we know, because he had to pick up his W-2 there. He's known at Dukes. So this is not any evidence at all that Max intended to kill Sade. And like many people do, they went out after drinking and they went back to his house. We asked you in jury selection, all of you, we asked the question of whether or not you would insist that a defendant testify. The defendant has a constitutional right not to. That's a hard principle for some people to embrace. You don't have to testify. The system doesn't require that. It's human nature. It's to want to hear sometimes, you know, like we say to our children sometimes, what did you do? What happened? Give me the side of your story. But that's how we handle things in our personal lives and not what is required here in court. And I am just going to address the elephant in the room. Max didn't testify, right? We all saw that. And maybe some of you were thinking to yourselves that you wanted to hear from him. Maybe all of you were thinking that. Certainly, members of the public might have been thinking that. But he's not required to do that. The judge told you that. He's not required to give any explanation or prove his innocence. The system does not ever require a defendant to prove their innocence. It requires the state to prove that he intentionally killed her. I didn't see any evidence of intent when I sat through this trial. The state points out things that they say Mr. Anderson did after the fact, which would demonstrate, if he had done it, an intent to commit other crimes, mutilation of a corpse. But I didn't see anything, and I listened carefully, and I know all of you did too, that shows any intent to kill. And that's how it started, and now there's a reckless homicide charge that you're supposed to consider as well, but I didn't see or hear any testimony about Mr. Anderson acting recklessly towards Sade at all. And those elements have to be proven. It has to be proven. In words, as the jury instruction said, words, actions, behavior before the event. Well, what are they pointing to? I'm asking that question. What are they pointing to? They're pointing to things afterwards that they say Mr. Anderson did, which they want you to bootstrap into a conviction on an intentional homicide. But that's not what the law says you're supposed to do. The law says you're supposed to look at each count separately. The law says that a defendant doesn't have to prove his innocence. The law says that they have to prove intent or recklessness beyond a reasonable doubt. The highest possible burden you could imagine. Not just that we think he might have done it, or last person with her could have done it, but that he intended to do it, or that he did it recklessly. And I don't know, based on this record, candidly, how she died. I don't know that any of us do. The medical examiner doesn't. Medical examiner is unable to tell us that answer. It's their job. Certainly the anthropologist we heard from doesn't know. And I talked about this with all of you in opening, that they have the burden to prove everything beyond a reasonable doubt. And if they don't, we don't have to put on any evidence. We don't have to put Max on the stand. We don't have to call witnesses to say A, B, and C. And I told you in opening, we weren't going to dispute, I forget what I said exactly, but I probably said we won't dispute 90+% of the case, because we don't. Everything Mr. Vance Curzan just showed you about the vehicle traveling to these locations, we dispute the big things, that it's Mr. Anderson intending to kill her or recklessly kill her. We dispute that he committed the other crimes, but the fact that they went on a date, the fact that they were together, the fact that they were friendly with each other, they drank, no dispute. The vehicle being shown on camera all over the place, the locations it went, no dispute. What we do dispute are a number of important points that I don't think have been proven. You never once see Max getting into this Honda Civic, nor do you see him getting out of the Honda Civic. You don't see him get in and you don't see him get out. And there was a video that was played very early on in the trial that all of you will remember because it was day 1 or day 2, but there was a video of the Honda Civic when it is in flames, basically on Lisbon Avenue, if we all remember that. And there's 2 women on the street who are on tape pointing in that direction. And you can obviously see that Max is in that area. I told you in opening, sometimes people can be in the wrong place at the wrong time. I don't have to prove, I have no burden to prove why Max was in that area. That is burden shifting, is not required. They have to prove that he was the one that exited the driver's door of that car and lit it on fire. They did not call either of those women in their case. They could have chosen to call either of those 2 women on the street and put them on the stand and say, is that the guy who lit the car or is that the guy walking near the car? Big difference. They could have asked them any question they wanted. Of course, we would have been able to ask questions too, but they could have put, her name is Laura Dyer, you heard that through other witnesses. They could have put Laura Dyer on the stand and asked her, who were you pointing to? What were you seeing? What did you observe in the minutes leading up to that? Who got out of the car? What side did they get out of, ma'am? What side did they get out of? If they got out of the car, how did they light the car on fire? They could have asked all of those questions and answered all of those questions for you. And we know for sure that she was shown a photo array because I asked one of the detectives about the photo array procedure. We know for sure it was shown and they didn't introduce it. I'm not here to hide a thing. Study it all. Study every piece of evidence that they gave you in this case. But they didn't call Laura Dyer, who I would argue would be the one witness you would call in your case if you wanted to prove that Max lit that car on fire, instead of being near it. And if we work from there forward, if we look at his behavior afterwards, Max's behavior, it's Max there, his behavior afterwards, they haven't proven what was in his backpack. But if we look at his behavior afterwards, he is not, as they just said, concealing his identity. Now, if you lit a car on fire, there's 4 ways you can go: north, south, east, or west. And I would argue that the last direction you would go is right down to Lisbon Avenue if you did that, onto a public street with cars whizzing by and buzzes everywhere and getting on a public bus. Actually, if you looked at the video, there's an alley right there. The more logical way to go is just dart up through that alley, get away, duck through houses and backyards and run. Max is walking. But look at his shoes, because their theory that they've given you in this case is that Max, prior to this, first of all, their theory is he killed her in his house without Pete Warburton hearing a thing, who's right below him. No struggle, no stabbing, no nothing, no help, nothing. But their theory is he killed her there. But then in the rainy day, pouring rain for days, muddy path down to Warnemont Beach, their theory is that Max did all of that. Why on earth, when he is walking on Lisbon Avenue, and you can watch the videos, look at the shoes. They're pure white soles. At least the sides, even the detectives testified to that. His shoes are white. Somebody who has been trudging through the mud, dispersing body parts in Warnemont Park in the pouring rain, in the bad conditions, does not have white shoes. No way. Muddy shoes, for sure. Watch the whole bus video. He doesn't, as they said, he doesn't pull out a phone or he sits there the whole time. Shoes are white. That is inconsistent with somebody having been at Warnemont Beach earlier and doing all of these things just a few hours earlier that they say. The sweatshirt that was located in the trash can, we had some testimony a few days about that. I don't know what to make of that. I don't know if it was planted. I don't know how that sweatshirt got in that trash can. But I know that if somebody was trying to destroy evidence, they could burn it right in the backyard. There's a burn pit right there, and they would be unlikely to ditch it right in the alley 2 houses down from them. Seems like a really unlikely thing to do. But what you didn't hear about the sweatshirt, and we know it's found on April 12th, after Max has been arrested. He was arrested on April 4th. So 8 days later, they find this sweatshirt. And how on earth is a detective, I think it was Lopez, how on earth is a detective on April 8th, he told you his job was to go down this alley to look in the trash cans. Remember, he was going to go look for clothes or evidence. If you were going down an alley to look for clothes or evidence, and he's now telling you, I remember seeing a sweatshirt in a trash can, but I just left it there. His job was to look for a sweatshirt or any clothes. I just find it really hard to believe. I think he's not being honest when he says that. I find it really hard to believe that if you found a sweatshirt in a trash can when that was your job to go the alley behind Max's home, you would grab it. And the trash came through on April 8th. Max is in jail. And there is none of Sade's blood on that sweatshirt. We were just told, again, he's wearing that sweatshirt supposedly when he dismembered a human corpse. The amount of blood and bodily fluid that would require, look at the video of him on the bus. If you can see a speck, there's no gloves on him. There are gloves at Warnemont Beach, which exclude him, but there's no blood on him at all. There's nothing on his hands. He's not wearing gloves. Max's DNA is also not on the driver's door of Sade's car, which is lit on fire, but her DNA is. So if their theory is that the DNA on the car driver's door was washed off by the fire department, why is Sade's DNA there? And his isn't. It's because he didn't close the driver's door. It was in the wrong place at the wrong time. And they swabbed everything. It was really boring. Some of the aspects of the trial were really boring for all of us because you had to sit here and watch grainy videos of what a detective thinks they see upstairs, and you have to listen to us on our end bore you, unfortunately, at times by going through all of the DNA evidence. But for crying out loud, this was the most swabbed home I've ever seen in my life. Swabbed everything. Everything. Ask for the report. None of Sade's blood is anywhere in that home. But she's been stabbed. He doesn't have any blood on him at all for a stabbing? and they don't have any weapon that they can connect to him that he ever used for this stabbing, or however she died, they don't know. But they do know for sure the DNA excludes him. It excludes him because her blood isn't in his home. Her DNA isn't anywhere in there. There's no smell of bleach. There's no indication he cleaned up. I would argue this does not look like a cleaned up place at all. Look at the photos. And there was a hair found on a proximal bone, one of Sade's bones, the hair that was found, and they thought for sure that's going to be Max's hair. We have a hair on a bone. I guarantee that's why they tested it. And look at the report. The hair on one of Sade's bones excluded him. Wasn't his. The video of the house, there's look at the pictures if you want to. It's grainy, it's poor quality. I also heard Rachel Smith said she spent 100 hours or whatever she said about the quantity of hours looking at video. The reality about the video is, again, we don't dispute that Max and Sade went back to his house. We don't dispute that they were there. Which silhouette is what or what it shows, your guess is as good as mine. I know that the FBI could look at it if they wanted to and was never asked of them to do that. They offer a witness with no specialized training in an effort to convict Max of homicide to say, well, I saw this silhouette and that silhouette, but they didn't do any height analysis. They didn't ask the FBI to be involved. And it doesn't show anything that we don't already agree happened. They were back together. But that front window is piled full of plants and other debris and miscellaneous things in there. So it's unlikely that there's really a whole lot of interaction you can truly see. It's probably dogs run around. I don't think Max is so sophisticated of a guy. I'm representing him. We heard from Pete Warbington. I don't know that Max is the most sophisticated guy out here. He's a smart guy, but he's working 3 days a week. He's a bartender. And Pete Warbington says, I complain about a hydraulic arm. He won't fix it. And Max doesn't like hearing that he's a bad landlord. I know. But the reality is that he's not a highly sophisticated guy where they introduced all sorts of evidence of his planning and research on wanting to kill someone. 30-some years living in the area, working for a decade as a bartender, well-known throughout the city. They didn't introduce one weird thing about him. No psychological profile evidence to show you that he fits the pattern of someone who's gonna just decide I'm gonna kill someone tonight after a date where I went everywhere that everybody knows me and I've never researched it and I've never looked into it, nor have I even so much as looked at how to dispose of a body or remove body parts, which you can only imagine what kind of feat that is. Use your common knowledge of even examples you can think of cooking about how hard it might be at Thanksgiving to remove a turkey leg, let alone a human. No research on it, no planning on it at all. Again, that's because he didn't have any such plan to do anything like that. It's not that secret of a beach either, if I can just say that. I mean, a few hours after someone is down there in the rain and the horrible conditions, there's 2 kids there a few hours later. In that same spot, right? They're there. They find a bone or a leg. So it's not that secret. It's Warnemont Park. It's a public park, 18-hole golf course. Everybody in the community is familiar with that area. Officer DeSmet testified, he's very familiar with the park. People go there all the time. We have 2 youngsters there right away a few hours later finding human remains. So not exactly a secret area that nobody's ever heard of before. What is Max's behavior afterwards? A lot of times in our human affairs, and state has told you, use your common sense. The reason they keep saying common sense, and again, I didn't tell you not to use common sense. I talked about this in opening. Go ahead and use it. Use it galore. But also, please look at the evidence. You have to do more than just base things on this expression, common sense, okay? Look at the evidence. We do know that somebody who committed a crime like this, who had done something like this, when they haven't, would be highly likely to change something about their life. He didn't do any such thing. He continued to go about his day-to-day affairs. You heard that he went to work at Dugout 54 the next morning, and his phone died not turned off intentionally. It died during the hours that one would be asleep. And he went to dugout 54, and he worked at dugout 54, which was his job, the next day. No issue. You didn't hear from one person who said that suddenly his behavior was different or that he started acting strange. He continued to work, stay in the area, didn't cut his hair, didn't change his appearance, didn't have a whole pile of cash in his car with a passport to Mexico, none of that. Just going about his day-to-day affairs. That's because he's innocent. And the police are the ones who make a decision on what to collect and what not to collect. And they give you that evidence, and then you decide whether it is proof beyond a reasonable doubt. They could have asked for more footage if they wanted to see what was going on the side of Max's house in the days after, or the alley in the days after. Does he ditch a sweatshirt in a trash can? But they chose not to, because they zeroed in on him, they zeroed in on a time frame, and that was all they needed to do. I know that when the evidence shows that when Sade's car left Max's house, and you never see him driving that car, when it left that house, and we know things can happen in an alley, when the car left that home, it went straight to Sade Robinson's apartment building. I never said it went there, to be clear. I never said she went in there. I'm just saying, what are the odds that with no evidence he even knew where she lived, that Civic goes from his home right past the building she lives in? A hell of a coincidence. I think it's very likely that perhaps something happened to her in the alley and perhaps she was directing them where to go. I don't know, but I do know maybe it was a stalker. But whoever did it obviously had an idea where she lived because they went right from point A to point B. I think the reason that the state spent such little time talking about the DNA evidence for you is because they know how powerful it is for the defense case. But we don't have to prove that DNA proves proof his innocence. They have to prove beyond a reasonable doubt that he's guilty of each of these crimes, that he intended to kill her. Now they're saying recklessly, but either one, whichever one they're saying. They had to form that intent or that reckless decision before. There's no evidence, by the way, of any reckless behavior at all that they've shown you on video, that they've shown in his house, that they've shown at all. But the reason why they spend so little time on DNA and they sort of brushed past that, and yet they'll spend days and days and days going through monotonous video of things we don't dispute, is because they know that the DNA evidence is powerful for us. And I ask that you look at the evidence closely. That's all I can do. I turn Max over to you. It's your decision. You have to look at each count carefully, and I'm convinced you'll conclude that the state hasn't met its burden of proof on each count. Thank you.